and thank you everybody for joining the presentation today. Again, as Mark said, I'm Andrew Martin, an associate at Scott & Scott, and this webinar today is intended to be a survey of the various issues that IT procurement professionals and attorneys should be able to identify and manage when negotiating a technology agreement. At the end of it's going to take a while to get through all these topics. There's a lot to cover. I don't think I'll have time to answer any questions at the end of the hour, but feel free to email me with any questions that you have, or you can enter them into the little panel on the side here, and I'll address those at the end of the presentation via email. You can also call me if you've got any questions. So we'll start today by discussing the IT procurement agreement types and the various terms that are unique to and important for each. We'll look at hardware agreements. We'll look at professional services agreements. We'll look at software and outsourced IT agreements. Once we get through those, we'll start talking specifically about the key provisions that are really important for everybody to understand when entering into a technology agreement. These are going to include indemnity, IP ownership, insurance, and limitations of liability, as well as privacy concerns. And finally, we'll discuss some practical tips when negotiating these contracts that I've found to be helpful to get the best deal possible for your client. So we'll start here, again, like I said, talking about the IP procurement agreement types. Under the hardware agreements, we'll talk about traditional asset purchases. We'll talk a little bit about hardware leases and then hardware as a service. For professional services, we'll be discussing consulting and development agreements. When we talk about software, we'll look at traditional perpetual licensing. We'll look at enterprise licensing. We'll look briefly at software as a service type licensing and service provider licenses. And finally, we'll talk about outsourced IT, which is going to include managed service providers and co-location agreements. As we look at these agreements individually, I'll briefly describe the general nature of each type of agreement, and then also talk about the terms and conditions that are unique to each. Okay, so starting here with hardware, there are three types that we're going to cover. Like I talked about, traditional asset purchases, which would include buying servers or desktops or network infrastructure and that kind of thing. We'll look at leases, where the hardware is returned at the end of the term, and software as a service, which is traditionally for hosting and servers, but now recently has been extended to hardware as a service for desktops and other infrastructure items for your organization or your client's organization. So when we look at asset purchase agreements, it's important to understand that this is what everybody is most familiar with, probably in the hardware sphere, and it's important to understand that these are sale of goods contracts, so the UCC is going to apply. The UCC is the Uniform Commercial Code, and it has a set of provisions that apply to all of the agreements that fall under its purview, unless the parties contractually agree to different terms. We'll talk about that a little bit in just a second. But a couple of the main terms that we're going to look at here are the delivery terms and risk of loss terms. And these are traditional procurement issues. And what you want to do is to make sure that you understand which party is responsible for the goods during shipping, who needs to insure the goods during shipping, and whether the shipping dates are material to the value of the agreement. So if your client is buying a set of servers that it needs on a specific date for an implementation, you want to make sure that that date is specifically outlined in the agreement and that it is noted that that date is material to the terms of the agreement. It's the basis of the bargain, and to ensure that the vendor has to perform on that day, or else your client could cancel the agreement. If you don't do that, there are situations where the vendor has a reasonable amount of time to tender the devices, and that may injure you, and you don't really have much recourse if you don't make it clear The other thing that will happen for asset purchase agreements a lot of times is you're going to have related installation services. And so the way that these come over in terms of the contracts, the way that these come over to the client are going to be an asset purchase agreement and then a separate statement of work that the vendor is going to deliver that says, here's the project, here's our installation services, here's when we'll be there, and those kind of things. The problem with that in some cases is that the statement of work doesn't sufficiently provide for all of the terms and conditions that you'd normally want to see when a vendor is delivering professional services or having consultants on site. So you want to make sure that when you're looking at the hardware asset purchase and an associated statement of work, that the statement of work includes those professional services terms and agreements, or terms and conditions that you'll want to see. And we'll talk about what those are in a little bit, but it's something to be cognizant of. For leases, hardware leases are a great option for companies that have room in their operating expenses budget, but don't have as much room in their capital expenditures budget. Before you enter into these agreements, regardless of whether it's an asset purchase or a lease, you need to be sure that you understand what the hardware refresh rate is. So as the attorney or the IT procurement professional, you want to make sure that you understand and have consulted with your technology folks to understand how long you expect for those particular hardware items to last, and how long you think that they'll be valuable to the company. And in the lease situation, then you want to make sure that the term ties to that expected life of the hardware. And so I have on here also hardware disposal at lease end. That's a beauty of the lease, is that you give the hardware back. You don't have to hang on to it or otherwise dispose of it. But you want to make sure that that's set out in the agreement as well, that there's a process, a procedure to go through to get that hardware back to the vendor. The next item here is hardware as a service. This is a derivation of the hardware lease agreement. It essentially will combine the benefits of your operating expenditure versus capital expenditure analysis that we talked about under leases, and then it bundles that with a utility billing model under which your client will only pay for the hardware that it uses. So instead of leasing a bunch of servers and maybe not taking advantage of the full capacity of the servers because your business, you've sort of leased more capacity than what you need to take into account your need to expand at some point in the future. Under hardware as a service, you're only ever paying for what you use. So your expansion is not, you're not having to fund the expansion up front. And fees under a hardware as a service agreement are typically going to be recurring monthly fees. And a particular concern to these kind of agreements are, where you have recurring monthly fees, you want to have pricing protections to limit the amount that the fees can be increased at the end of the initial term. You're also going to want to talk about, we talked about capacity a little bit, you want to make sure that you have capacity guarantees in place in these kind of agreements. You want to ensure that the vendor has enough excess capacity to handle your projected usage, not only over the initial term, but well into the future if possible. This is because obviously there are switching costs that have to move from one provider to another, and if your provider can't guarantee or otherwise assure you that they're going to have enough capacity to meet your needs well into the future, it may not be a good fit. The other thing is that you need to look for, and we're going to talk about these a lot, but it comes up over and over through the course of dealing with these kind of contracts, is the service level guarantees, or generally you're going to see those in a document called the service level agreement, or SLA. And depending on, we'll talk about what an SLA, some of the details of an SLA in a little bit, but essentially, look at how critical the hardware is to your client's business for these kind of hardware as a service agreements. And where the hardware is very critical and it's, something that's important to carry on the client's business, you are going to need to make sure that you have an ironclad service level guarantee in place with respect to server uptime, otherwise with respect to availability, those kind of things. We'll talk again, like I said, about SLAs a little bit later on today. So the next slide is we're going to discuss professional services agreements. And when I'm talking about professional services agreements here, I'm specifically talking about project-based work. And what you'll see when you're looking at the agreements that are sent over by the vendor is a master services agreement and individual statements of work that essentially hang off that master service agreement and define the projects that are to be performed. Today, we're going to look at specifically consulting and custom development agreements. So the big issue under consulting, and actually it applies to custom development as well, is the issue that I'm sure everyone's familiar with here is the idea of scope creep. And scope creep is when, scope creep occurs when the statement of work doesn't adequately set out the deliverables and milestones on a particular project. A lot of times you'll see statements of work come across or proposals from a vendor that, don't have really much, if any, specificity as to what the project's going to look like, what the timelines are associated with the project, how the, who the responsible parties are for each particular item. Where you don't have that definition, that specificity, and a statement of work, you can almost guarantee that your client's going to be the victim of, a project that suffers from scope creep. Again, it's just the statement of work is just too vague. And so what you want to do is to make sure that when you're looking at these agreements that there is enough oversight built into the project by, those who are going to manage the high end, manage the project from a high level, and then also make sure that you've assigned responsible project managers, and that should all be defined in the statement of work. Another issue to look at when you're looking at statements of work are how to replace team members from the vendor side who are not getting the job done. First thing you need is the right to replace a team member at your reasonable discretion or your client's reasonable discretion. They should have that ability. And then, secondarily to that, you need to require that the vendor replaces the replaced team member with an employee or a contractor that has, at least equal to, if not greater, experience than the replaced member. So you don't want to get somebody in there that isn't capable. And it's a good idea to have these kind of terms in the agreement. The other thing I have on here is just kind of a general thing, but something that can prevent some hurt feelings down the road or some disputes as to expenses. Just make sure that the client is only on the hook to pay for pre-approved expenses. When we're looking down the road at custom development, developer agreements, the big issue in these agreements is IP ownership. We're going to talk a little bit more about IP ownership later, but there are some things that we should highlight at this point. A lot of times when you're looking at development agreements, if it's a custom sort of project to develop software for your client, many times the vendor's default agreement that it's going to present to you will say that it owns the code. It says it owns whatever code it develops. And, it's a default position for the vendor and can be understandable from their perspective. But obviously from the client's perspective, this is problematic for a variety of reasons. But the most common sense reason for you to argue this point is that your client's paying for this work. So to the extent that they're paying for the vendor to perform this work, to develop this code for them, your client should own it. And that's pretty simple. And in my experience, the best way to address this issue is to, a lot of times the vendor is going to say, well, we can't really separate or identify what we're doing for you that you're paying us to do, that the client is paying us to do, and what we have brought to the table. And so, we'll talk about this again in a little bit, but, what it comes down to is saying that anything that they bring to the table, they being the vendor, belongs to them, and anything that they develop, the vendor develops under your client's agreement, belongs to your client. Sometimes this still won't work. This argument really doesn't work in some cases where the custom work is related to building an integration piece from software that you have already installed that is owned by the vendor, and the vendor is going to custom develop an integration piece that will link to another system that your client has on its network, and the vendor intends to use that integration piece as a product enhancement going down the line. And if that's the case, and it's not something that the parties can really come to terms on whether or not the client is going to own it, then the way that you can work around this is to give your client a perpetual worldwide license to the code that's being developed that it's paying for, and included in that license would be the right to access the code, the underlying code, and use and exploit the underlying code in any way within its own organization. The next topic is software licenses. Software licenses come in a variety of forms to address a wide range of circumstances, obviously from traditional perpetual software licenses that count individual users or installations, to enterprise or estate-based licenses that allow an organization to install as many licenses as it needs, to software as a service model, which we sort of talked about. This is the precursor to the hardware as a service model we discussed earlier, which is essentially a utility-based software model. And then there are also, service provider licenses, which allow your client to buy the right to provide the publisher's software to third parties. So starting with traditional software licenses, there are two things that you want to understand when you're looking at any software license, and we're starting with traditional. The two things are, what are the use rights, and how do you count your deployments? So how do you count the number of installations or licenses that you've used and that are on your client's network? Back in the day, an off-the-shelf software package was pretty easy to count. Essentially, you buy a package of software, Microsoft Office, you install it on your computer, and you have that one license to use with that one computer, and it's straightforward. There's not a whole lot of need to interpret the license agreement. But even now with those products, those simple products, you'll find that publishers, Microsoft is one, a lot of others are giving you the ability to install that one fully packaged product on multiple computers, subject to some restrictions, but one box, one license can now be installed on a number of machines. And counting becomes even more complicated for enterprise licenses, which we'll discuss in a little bit. But so you need to know where you're allowed to use the software and how you are supposed to count it, and that takes a really careful understanding of what the license says and an understanding of how your client is likely to deploy the software. The next issue to understand on traditional software licenses, or really any of these other ones as well, are vendor audit rights, and these can be a real big deal. Vendors generally are going to want the right to audit at any time, and two, will want to transfer the cost of the audit to the customer. That's obviously not a good position for your client. The best agreements from a purchaser perspective allow, first of all, only periodic audits. So that'd be like once per year or once per term of the license, or even less if you can do it. And then the other thing that you want to look for from your client's perspective is a provision that permits the customer to choose to self-audit and self-report, as opposed to letting the publisher or more traditionally a third-party auditor on site. That can get really hairy. can get really expensive. You want to, as the client, control the information as much as possible and be able to look through and interpret your installations and your accounts on your own without having a third-party auditor there to put their own spin on what the accounts look like. For enterprise and site-based licenses, what we're talking about here is where a company purchases one license or signs one agreement essentially, and is not limited then on the number of installed instances or users for that software. When I say not limited, that's not exactly correct. They are not limited in the short term to install or otherwise deploy the software on their network, but these licenses are generally going to come with a periodic, what they call true-up obligation, which means that you count your deployments and you submit the number of deployments that you've had over the preceding period to the publisher, and you pay some amount that's commensurate with the number of additional deployments that you have installed on your network. And what this does when it works well is allows a company to, it's easier for that organization then to manage their deployments because they're not having to buy software ad hoc that they can roll. They can just deploy the software as it's needed and then have one event every period to handle the actual orders. What you need to be concerned about here are the soft costs associated with complying with the true-up requirements. So if the true-up, if the license isn't carefully drafted and doesn't actually take into account the way that the software is going to be used or deployed on your network, on your client's network, then what happens is that you have situations where these true-up obligations become very difficult to comply with. It takes a long time for your organization to count your deployments. You're not real sure about the results that you're getting. You don't have a good asset management system in place, or the deployment counting method doesn't actually match the way that your client is going to use the software. So it can become very expensive just internally to comply with true-up requirements. And if you're not careful, what happens is you end up eating up whatever savings you got from signing on with the enterprise license agreement to begin with. So again, counts are very important, and how to count is very, very important for software licenses. Under the software as a service model, this is a pay-as-you-go, pay-for-usage type of model. Generally, the data is stored on the vendors or its subcontractors' servers, so agreements really need to include assurances as to data privacy and security that are appropriate for this particular application that you're using. You're also going to want to look for cyber liability coverage in the vendor's insurance requirements. Both of these points we're going to get to in a little bit, and I'll talk about them in more detail. But those are the things that are important under a software as a service model. The last bullet point here is to talk about service provider licenses. Similar to the SaaS model, only your client is acting as the service provider, and your client is sitting between the publisher and the end user. So your client as the service provider is required generally under these agreements by the software publisher to do a couple things. One is to, again, back to the counts, count the number of software instances that have been deployed to the end users. And also the publisher is going to require your client to ensure that end users are complying with the publisher's license agreement. I see a lot of service providers that don't fully understand their obligations with respect to counting the deployments. These agreements can get very, very complicated, and especially when you get into virtualization and clustering and different ways to increase the efficiency of the hardware that you have that's delivering the software, counting becomes really difficult, especially if you don't understand the technology well. So it requires a really concerted effort between the IT professionals with your client and the lawyers or procurement folks to work together to understand what the true-up obligations are. And those are going to come in a service provider license agreement. Those true-up obligations are generally going to come on a monthly basis. So you really need to stand up a process that does a very good job of counting and keeps you in compliance. The next type of agreement that we'll talk about are outsourced IT agreements. And they're similar to and really can be considered a subset of professional services agreements. We're going to talk about a couple different kinds here, the managed service providers and co-location agreements. So what a managed service provider is, or we'll call them MSPs, the MSPs are companies that handle much of the IT support and services for your organization, for your client. This includes management and monitoring of servers and desktops, handling end user support requests, troubleshooting, sometimes maintenance. There's a host of different types of services that can be offered, and this sort of brings us to the first point here under the MSP heading, which is specify responsibilities. When you're looking at the MSP agreement that the vendor gives to you, you want to be sure that your client understands which services are specifically included in the agreement. There will generally be a laundry list of services that the vendor is intending to provide, and they should be carefully set out and delineated. What the MSP is also going to do is to set out those servers that are not included, that are specifically included from the service offerings. And what you want to do here is to make sure that there's not an exclusion in that excluded services list that swallows all of the included services. So, for example, sometimes the vendor is going to have a excluded item that says something like the vendor is not responsible for server downtime caused by factors outside of its control. Factors outside of its control is way too broad for that to be included in the agreement. The whole idea, the reason why your client is getting a managed service provider in the first place and engaging with one is because it doesn't want to handle factors outside of its own control. And so it's offloading that risk to the MSP to do that. You want to tighten up that language if the exclusions are very broad. Again, back to the service level agreement, or SLA. This is important here in MSP agreements that the MSP defines the agreed service levels, which would include server uptime. For MSPs, you're going to get a service level, or you should see a service level for trouble ticket response times. Those are things that are really important to get set out in the SLA. And not only should there be guarantees, there should be they should also set out what happens when those guaranteed levels aren't met. So the vendor needs to, generally is going to give your client a service credit to be applied to your client's next month's bill in the event that they fail to meet their service levels. What you want to do here is make sure that those credits are meaningful to the vendor and that they're painful enough to incentivize the vendor to actually meet its guaranteed service levels. The other thing that you want in this kind of an agreement is the termination for cause provision. Most of these vendors will, most MSPs, and nearly all of them, are going to attempt to lock your client into an agreement for a specific term. And by locking them in, they're going to include a penalty for early termination that would dissuade the customer from doing so, from terminating early. What you want to do is ensure that your client has a termination for cause provision that's tied to repeated or chronic failures to meet the guaranteed service levels. This termination for cause provision should allow your client to get out of the contract without paying that early termination fee. And again, tie that back to the SLA. Say that if the vendor fails to meet its service level guarantees, 5 times over 2 months or 7 times over 3 months, then your client has a way out of the agreement without paying that early termination penalty. The next item here is co-location agreements. This is company-owned equipment, client-owned equipment that is running in vendor-owned rack space, or what these agreements are for. And generally, the rack space is going to include redundant power, physical restrictions on access, disaster recovery, and disaster prevention systems. And so the agreements are going to need to include, again, an SLA that provides for service levels for all of those particular services, and failures to meet those service levels are something that you will want to receive credit for, make sure your client receives credit for. The other thing is here, again, similar to what we talked about earlier with hardware as a service. In fact, these are fairly closely related type of agreements, is that you want to have guarantees as to the environment's expandability to meet your future needs. So it's the same analysis that we did under hardware as a service. You want to do that here and ensure that there's a future capacity guarantee in the agreement that meets with what your projected growth plans are. Okay, that's it for the types of agreements. The next thing that we'll talk about here are the key provisions to look at. In this section, we'll take a deeper dive on some of the more important provisions to understand when negotiating these agreements, including, as you see, indemnification, IP ownership, insurance and limitations of liability, and privacy concerns. And as we look at each of these provisions, I'll talk about the types of agreements that particular provision is especially important for. All right, so we'll start here with indemnification. For anybody who's not comfortable with how indemnification provisions work, they're basically an obligation on one party, in our case it's going to be the vendor, to act on your client's behalf when a third party asserts some claim against your client, and that claim is based on something for which the vendor is responsible. And when I say that the vendor is obligated to act on your client's behalf, what I mean is that the vendor, generally what that means is that the vendor will pay for the costs associated with defending the claim, which would include legal fees and damages in most standard indemnification provisions. In addition to those two things, legal fees and damages, I also recommend being more specific as to the other potential costs for which the vendor may be responsible. That would include things like investigative fees or audit-related fees. This is really important in software as we discuss software contracts. Subpoena and witness costs, and punitive damages. Again, punitive damages can come up for infringement matters, so you want to make sure that those are included as well. So that's just an overview of how indemnification works. So back to the actual events that can trigger an indemnification obligation. We are primarily concerned with here, one, negligence and willful misconduct on the part of the vendor, and two, IP infringement. The negligence issue applies, pretty much across the board to any of these agreements, where the vendor is required to indemnify your client for any claims that arise because of their negligence. Sometimes that's not going to be included in the indemnification provision, but when you add it in a red line and pass it back, it's really hard for the vendor to argue that that's not a reasonable position to take. But the big issue here is IP infringement. This is what we're primarily concerned with in indemnification under technology contracts. So what we're saying here is that when the vendor is delivering some sort of technology, and it doesn't really even necessarily need to be technology, it can be documentation or user manuals or that kind of thing, but if they're delivering some sort of IP, it can be custom or off-the-shelf software, it can be hardware, again, like I said, user manuals, etc. You want to ensure that the vendor is going to defend your client for any infringement actions brought against your client by a third party based on the use of that IP that was delivered by the vendor. There are a couple things to think about here. That's pretty basic. A couple of things to pay attention to, just kind of the specifics, is that there are a couple ways that you can get this this indemnification provision worded. One would be that the vendor will indemnify your client against all worldwide intellectual property claims. This is obviously the better position for your client. But you're going to see some reluctance on the part of particularly like software publishers to provide that kind of a worldwide intellectual property protection. Their argument is that they can't control or monitor or otherwise analyze all registered IP across the world, so they can't be held responsible for some party in China, for instance, who says that their software infringes on the Chinese company's IP. You know, this is an argument that I have over and over. I don't necessarily, from the client's perspective, agree with it. It's going to be sometimes difficult for you to convince the vendor otherwise. But I will tell you that generally speaking, if your client is a larger, specifically and especially if it's much larger than the software publisher, then you will need to demand that you have worldwide IP protection. And the reason is because the reason your client's going to get sued is because your client has deeper pockets than the publisher. If your client is relatively small compared to the publisher, the third party is going to look instead to the publisher if it has an IP infringement claim as opposed to your smaller client. So it kind of depends on the relative size of the publisher to your client to determine whether or not, you know, these kind of provisions worldwide versus U.S. or other regional IP protection is something that's important. The other thing to look at is to ensure that your client's getting IP protection against all intellectual property rights. A lot of times you'll see the vendor paper says that it's only going to protect you and indemnify your client on claims arising from copyright or patent infringement. It's a better practice, if you can get it, to get trademark and trade secrets included in the indemnification provision. The next topic here is IP ownership. These provisions aren't necessarily just going to be located in one specific place in an agreement, so that's important to understand. You'll have to look through the agreement and look to different parts of the agreement to find the areas where intellectual property ownership is implicated. But when we're talking about ownership of IP in this context, generally we're looking at two specific types of IP. One, and we've touched on both of these already. One is the IP that's developed by the vendor for the customer. That can be custom code, website content, graphics, patentable inventions, written documentation, etc. There's a lot of things that would be considered IP that the vendor can develop for your client. The other is your client's data that it brings to the engagement that is stored by your client on the vendor's systems. So when we're talking about cloud-based, software as a service-based service offerings, it becomes very important to understand what the obligations are and ownership rights are with respect to that data. So starting here with the first bullet that says you own what you bring, we own what we pay you to build. We talked about that a little earlier. It's a very fair place to start from when you're talking with the vendor and you're negotiating, you know, who owns what. That is the best place to get started. That means the vendor owns its vendor materials, which we talked about, code snippets, frameworks, functions, whatever it brings with it, and the customer owns all of the work. Well, the customer owns everything it brings to the table, plus all of the work that the vendor performs that the customer pays it to do. The thing to pay particular attention to here is to make sure that if you get this deal that you own the vendor work, then you need to make sure in the agreement that the vendor work is defined as a work made for hire that is owned by your client. Under the relevant copyright and patent provisions, the default position of the law is to say that that a independent subcontractor owns the intellectual property on any work it develops and is paid, even if it's paid for by a third party. So default position is the vendor would own it. You need to make sure to override that with specific language that says the work is a work made for hire under the relevant copyright or patent framework. Next bullet point here is you own your data. This is where I'm talking about customer data that's stored on the vendor's systems. You need to make sure that the agreement retains all rights to the data to your client. And there can be some issues here. That's a simple, easy way to start, is that your client owns it, right? Makes sense. The issues come or arise here where the vendor needs to access the data because maybe it needs to analyze the data or perform some other sort of compilation of the data as part of the service that it's offering to your client. So if that's the case, if the vendor is going to have some access to the data, it's a good idea to have a specific license set out in the agreement that defines what that type of use is, and for the vendor to access your customer's data, and sets out that it's a limited use license and that it's only good for the period of time that the term of the agreement, etc. And then a really big issue here, and really important to get into these agreements, is an effective termination clause. So to the extent that your customer or your client is storing its data on the vendor system, you want to ensure that that data gets back to your customer your client at termination. And termination should be expanded to include termination of the agreement for any reason. Sometimes you'll see these vendor agreements that say they'll give the data back, provided there isn't a dispute over fees, or provided that the agreement wasn't terminated for arising from your client's breach. Not acceptable. Neither one of those are acceptable. You need to get that data back. That data it's your data. No matter what the reason for the termination, you get it back. There's no holding hostage of data. The other thing that you want to do is make sure that you get the data back in usable format, not in a bunch of reams of paper or printed out, a database printed out to PDF or something like that. It needs to come back to you in a usable format. Okay, the next topic is insurance and limitations of liability. Generally speaking, we like to make sure here, that these two provisions, insurance and limitations of liability, dovetail with one another. It's a practice that gives the client the benefit of the proceeds of the insurance coverage made available to the vendor, as we'll discuss in a little bit. But first, let's talk about let's start with insurance, and then we'll discuss how it integrates with limitations of liability. So generally, you're going to require, general liability insurance. Everybody's pretty familiar with that. It covers bodily injury and property damage. Really important if you're going to have your vendor is going to have its consultants on site, that kind of thing. Next one you want is E&O, which is errors and omissions, or professional liability, sometimes referred to as professional liability coverage. This coverage covers losses arising from the negligence of the vendor when the vendor is delivering professional advice or services. Again, important for, especially you can understand for professional services agreements, to have E&O as a requirement for the vendor. The third thing here is cyber liability. We've touched on it earlier. Let's talk about it a little bit in more detail here. Cyber liability, generally what it covers are the costs associated with breaches of security or data leaks. So these costs would include breach notification costs and media liability coverage, those kind of things. And so let me give you an example. So where your client has personally identifiable information, or referred to as PII, that it's storing or is being accessed by a vendor, and that PII is subsequently leaked, there are state and federal laws that may require you to notify each individual whose data has been compromised. That can be a big expense if you're talking about a database of 5 or 10 million records that has been compromised. So cyber liability coverage, what it does is steps in when that happens and helps to mitigate against that risk, and really needs to be a requirement in those engagements that implicate sensitive information. So once you have the policies set out, the required policies, you want to make sure that you have policy limits that make sense with respect to the type of services being offered or the data being transferred, transmitted, or accessed. To do this, it requires taking into account the nature of the data being stored. Is it PII that could trigger a notification requirement? Or you need to also look at the volume or the criticality of the work that's being performed. The more critical work, the higher the limits probably. This requires a pretty in-depth internal discussion, and generally if you're going to go with high limits, it's going to increase the cost. The vendor's going to want to increase the cost of the services to you to help defray that cost for upping their limits if you're going beyond what their standard limits are. So once you've got the proper coverages and limits in place, the customer will want to ensure that it can access the proceeds that are available under those policies in the event one of them is triggered. And here's where we get to the dovetailing. So under a typical IT agreement, the vendor is going to limit its liabilities to the amounts paid by the customer. A lot of times it's going to say something like its liability is limited, the exposure under this agreement is limited to the fees paid by the customer over the previous calendar year. And what we like to do, instead of having that artificial limit set to the fees paid under the agreement, is to set liability limits to the dollar amounts available under the applicable insurance policy. So to the extent a policy is triggered because of vendor wrongdoing, the customer then has access to those funds that are available under the policy. You'll get a lot of pushback here. This is something that we've seen a lot more recently and have been doing for quite a while. A lot of vendors don't really understand what is going on here, and what they see this as is, so say they have $1 million coverage limit. What they see this as, if you put this language in the agreement, is that you are giving your client the right to access $1 million in case insurance is triggered. And that's not the intent, and that's not how the language would be interpreted. What the client still has to show that it's been damaged, and it's only going to get the amounts up to whatever amount it has been damaged. So if it's been damaged by $5,000, then that's all it's going to get out of that insurance policy. All we're doing here is not setting an artificial limit that is well below what might be available to the vendor to defray the costs associated with its wrongdoing. So depending on the bargaining position and sophistication of the vendor, you may have more luck. Excuse me, you may have more luck with this approach in one instance than another, but it's fair and something that we try to put into most of the agreements that we negotiate. The next issue here is privacy concerns. So we've hit on this a lot. It comes up a lot throughout the presentation. But here we'll look at other ways to protect, or the available ways to protect your client's data within the framework of these IT procurement want to have is a solid confidentiality agreement in place. And there's a lot that goes on with the confidentiality agreement, but one thing I want to highlight for everybody here is that when looking at those agreements, you want to make sure you want to pay close attention to how confidential information is defined. A lot of confidentiality provisions or agreements will say that confidential information is defined as information that or documents that are labeled as confidential. That's, in practice, really not very helpful at all. Most of the data that gets transferred back and forth between your client and the vendor is not going to have a label of confidentiality or confidential information on it. So the better position to take and the better language to use is language that says confidential information is defined as information that should be reasonably construed as confidential at the time of the sharing of the information, something to that effect, so that you take away that strict labeling requirement, because it really in practice doesn't work. Second thing to really understand when negotiating a technology agreement and trying to protect your client data is to understand what kind of data will be accessed or stored. Talked about that a little bit. You need to know what data is at risk. So is the data PII? Something we talked about. Well, I didn't really talk about what PII is. It's generally defined as information that can be uniquely identified to an individual. So the actual definition varies from statute to statute, but it's all pretty well related to that general definition. And it can include something like a record that has a name, a full name, first and last name, and then it can be reconciled to a driver's license number. So having both of those pieces together would be considered personally identifiable information. Same goes with like credit card numbers and those kind of things. There can also be, the data could also contain medical information that implicates HIPAA rules, or the data implicates the FTC's identity theft or red flag rules. You may be processing credit cards, so obviously you've got PCI compliance issues. These issues need to be well understood prior to entering into any agreement involving this kind of data. So you really need to understand what the data is. Next, you'll want to ensure the vendor is obligated to comply at all times with the relevant data protection statute. And you do that by stating it explicitly in the agreement. Where you know that there are particular statutes and rules that are more relevant to the kind of data that you're talking about, then make sure that those statutes and rules are included in the agreement and that the vendor agrees to comply with them. Where appropriate, it may also be helpful to require the vendor to provide a specific contact within its organization that handles privacy and security related inquiries. So having that contact set out in the agreement will go a long way to help you manage a situation where there's a data breach event. You'll know who to contact with the vendor, and that person should have the expertise necessary to help you navigate the sometimes painful waters that are associated with a data breach event. But if you do these things, hopefully they won't be quite as painful. Then you'll want the vendor to warranty that it's taking steps to protect the data, and that includes a warrant that it will maintain all appropriate technical, physical, and organizational security measures. Those are the three sort of prongs of security, information or data security. Technical security being like having the data encrypted. Physical security means like locked cages, locked access to office buildings, those kind of things. And then organizational security would be processes and procedures in place to deal with data breach events. So, where you need it, where you're talking about really sensitive or data that is subject to, some of these rules, then you're going to want to ensure that the agreement has all of these things in place. And finally, like we talked about, cyber liability coverage, make sure they have it. If if you've got any kind of data that has any kind of sensitivity like what we've talked about here, look for data, cyber liability. If the vendor doesn't have it, look somewhere else, or tell the vendor to get it. It's what you need to do in these cases. Whoops. Okay, so the last slide here is negotiation strategies. You know, these are things that I use when I'm negotiating these kind of agreements. There are any number of ways to approach a negotiation, obviously, for these kind of contracts, but the approach that I like best is the one that keeps everybody in a positive mood and works towards terms that are beneficial and fair to both parties. Not trying to fleece the vendor, just trying to be fair and protect the client. And the strategies that I've found to be the most successful when negotiating these agreements are the ones that set expectation up front. And, you know, this goes for both parties, actually. So a lot of times your client doesn't really have an expectation set or doesn't fully understand the process of the negotiation and what you're going to be asking for in the negotiation. And that is generally the fault of counsel. You know, if you're not communicating to the client what are the things that are important or what you consider to be important when the client's trying to get into an engagement for one of these kind of agreements, then the client can be surprised in a bad way as you move towards resolution and final negotiation on the deal, and you're bringing up issues that the client really didn't consider and probably did not, or certainly didn't convey to the vendor as being an issue. And now the client's in a position to look at the vendor and say, hey man, I didn't know that these things were important. Sorry we didn't talk about them earlier. You know, so the good first step, and it's not really on this slide, but the good first step is to make sure that you and your client really understand what terms are important in these kind of agreements. Again, the goal is here to reduce the likelihood of either party assuming a defensive position that would, you know, otherwise impair the process of the negotiation as it moves towards conclusion. All of these items that I have outlined here are really things that happen at the beginning. Again, talking about setting expectations, that means before you get into the nitty-gritty of the negotiation, which, you know, how that occurs really has a lot more to do with the various parties and their positions and that kind of thing, and their, you know, bargaining power. The things that you can control at the outset are things like the first bullet point here, sending out an RFP with your organization's standard terms and conditions. What that does is, you know, clearly that acclimates the vendor to the idea when they're, you know, putting together their proposals. They understand what terms and conditions you're looking for. To the extent that you're looking for, let's say, insurance provisions that are beyond what are their standard insurance policies, then they can understand that, okay, if I really want this business, then I'm going to need to consider and talk with my insurance provider, consider upping my limits, and, you know, where they need to, they can roll that that cost back into their proposed pricing for the client. Much easier for the vendor to do that on the front end than to do it at some later day as the negotiations unfold. So where your client is sophisticated enough and has the capacity to have RFPs that have standard terms and conditions is a great way to get the negotiation started off on the right foot. Second one that I'll talk about is really the third bullet point here. It's related to that first bullet point. While your client's still in the solution comparison phase, it's a really good idea to ask for the vendor's standard paper to review. So you can get a feel as your client is looking at the technology available from that particular vendor and sort of analyzing it and determining whether or not it fits its needs. You can be looking at that point at the terms and conditions, and a lot of times you can determine, you know, how well this vendor may fit into what you're trying to do based on the terms and conditions that they have. You can tell whether the vendor is sophisticated, has all the proper insurance in place, and understands intellectual property rights. You can tell a lot of that stuff by the license or agreement that they provide to you. And in doing that, you may have some insight as to which vendor would be the more appropriate choice. I'm not saying that this would be the primary decision factor from one vendor to the other, but it's good information to have up front. And finally, and this one is the kind of the best one and least used as far as I can tell. That may not be true, but it's definitely one that's the most effective, is to prepare the vendor for negotiations by requesting an editable copy of their standard paper at the beginning of the agreement. Don't do it towards the end. Do it at the beginning. The vendor then knows, okay, we're gonna have to review this, the terms and conditions. We'll have to the vendor has to get their counsel involved and that kind of thing. It goes a long way to preparing everybody for the fact that we're going to talk about terms and conditions, and this is something that is important to the client. So that's it. I appreciate everybody joining the call today. I hope you found some nuggets of information in here that were helpful to you and that can be helpful to you moving forward. Like I said at the beginning, if you have any questions, feel free to email them to me. My contact information is here on the screen. And for those of you that are waiting for the CLE information, let me pull that up and I'll get that out as well.